Good afternoon. I will call the September 1st, 2023 meeting of the Court Reporters Board back to order. We will continue on with agenda item 10. Ms. Fenner, would you like to provide the background on this item to frame the board's discussion?
Thank you, Chair Sunkis. Before I begin the background, our board counsel has some information to share. And I'm sorry, this is agenda 9 of item 10. Okay. Thank you. So oversight of fees can be a heated concept. It requires the board to balance protection of the public, statutory compliance, and legislative intent in a way that could affect licensee income. Therefore, as board counsel, I would like to provide some legal guidance for this discussion. The board is composed of licensees and public members to provide their perspectives on the oversight of this industry. Every member has an equal role. Moreover, the board listens to and considers comments made by the public. Then the members vote, and the Court Reporters Board of California speaks as one. Business and Professions Code Section 8005 provides that the Court Reporters Board shall carry out the purpose of its laws to license, regulate, and enforce those within its jurisdiction. Business and Professions Code Section 8005.1 provides that the protection of the public shall be this board's highest priority. Also, Business and Professions Code Section 8015 sets forth that the laws providing oversight of this industry are designed to establish and maintain the competency of court reporters for the protection of the public in general and for the protection of all litigants in particular, whose rights and personal freedom and property are affected by court reporters. As with all items, the Bagley-Keene Open Meetings Act requires orderly conduct to accomplish the people's business. Participation by the public and each member is highly encouraged, as is robust discussion, as long as it remains orderly. This will help the members to determine how best to protect the public. If the members have any questions before we begin, I will do my best to answer. Otherwise, I thank you for your time.
Thank you, Ms. Joffrey. There is disagreement in the court reporting industry on the ability to charge expedite fees to all parties in a deposition. Historically, the board has considered that the expedite fee is for the sole purpose of transcribing that proceeding before other work that the court reporter has. The fee is to be charged to the party that orders the expedite. Then once the transcript is available, it is to be sent to all ordering parties. There are some firms and/or reporters that are withholding the transcript unless each party pays an additional expedite fee. There's no basis for the additional fee, and therefore the board requests refunds to those consumers when we get a complaint. The argument has been that there are additional costs to preparing and delivering those copy orders. While that may have been true before electronic delivery, the board does not see the validity of that argument and maintains its position. Staff is requesting that the board confirm the current position, or in the alternative, instruct staff to notify stakeholders of any change of position. Additionally, we will hear from our staff, our board counsel, on the necessity for either regulations or statutory changes in order to clarify the issue for licensees and consumers.
Do we have any public comment before we move to board discussion?
This is the moderator. If anyone who's logged into WebEx would like to make a comment, you may look for the hand icon and click that to raise your hand. You may look for the question mark icon, click that, type the word comment into the text box and click send. And if you are a call-in user, you may press *3 to raise your hand. Each speaker will have 3 minutes with a 30-second warning. Are there any public comments on agenda item 10? I do have one request for comment from someone logged into WebEx as Mary Pierce. Mary, I'll send you a request to unmute your microphone and you'll have 3 minutes. You're unmuted. You can go ahead. Mary, we're not hearing your voice. Mary, did you change your computer setup or headphone use while you were on the lunch break? We're not hearing your voice.
This is legal, if I may. We can also have Ms. Pierce type in the comment if she is unable to speak.
Perfect. Thank you very much for the reminder. And then let's see. So we do have. All right. So Mary's comment from her text was, I would just point out the difference between, quote, shall make available, unquote, and, quote, must be sent, unquote. That is the substance of her comment. Are there any further requests for comment from anyone on WebEx? I do not see any further requests. Shall I close public comment?
Yes, please.
Thank you.
Are there any comments from board members? Board Member Brewer?
I didn't expect to be speaking so soon. So, I was surprised to see this on the agenda. And as a licensee for more than 40 years, I was surprised to see the board's position, and here I am, a board member. This argument, this position hinges on reasonableness of a fee. And I cannot support a position of not permitting a charge based on my career's work, the entirety of my career as a deposition reporter, and I freelanced for a lot of agencies. Every single agency that I worked for that I can't think of an exception, charged an expedited fee on copies that were requested expedited, as well as the O&1 that was requested expedited. As Ms. Fenner had noted, practice has changed, and things being digital, electronic, has taken some of the burden out of delivery and producing. But it's more than a mere commensurate work for a charge. If it were, this would also be a problem for the way court reporters charge for copies, because you just run a copy on a copy machine. This is how court reporters make their living. And this is a service that's given to put certain work ahead of other work. And it's a service and a benefit that's conferred upon the client. And historically, not only court reporters, but in other professions, people who are in it for a living charge a fee for that. They charge a fee for a service provided and for a benefit conferred on the client. So as I say, it's been the standard practice in my experience. And most of the reporters who I know, it's been a standard practice. Now that might be regional. I worked in the Bay Area my whole deposition career. So that's the sum of my experience. I know a lot of other reporters in the state, and it's apparently been their experience as well. Additionally, I think there are a lot of professions that we can look to where work is billed not for a commensurate number of hours or effort, but instead for a service rendered or a benefit conferred. I mean, you've got commission sales, insurance commissions, real estate commissions, any kind of a commission sale, and especially one where a commission keeps accruing for a renewal. That's typical. It's common. It's expected in a lot of businesses. Is that good for the consumer? I'll get to my feelings about the consumer because that is our mandate here, to represent the consumer. And I take that seriously. It would be a basic unfairness to people who are already in line to get their deposition transcripts delivered to put other people ahead of them. And when you start talking about providing it for free, okay, it might seem like a de minimis effort, but if everybody starts wanting things on the double, you know, in 1 day, 2 days, 3 days, it quickly becomes a production problem. Court reporters and agencies typically have to, not typically, frequently have to take a reporter off calendar for the next day when they're scheduled to do something so that they can handle an expedite, so that they have enough time to handle it. And historically, part of the compensation to the reporter is the expedite fee on the copy. Now, of course, if the copy attorney or consumer elects not to have an expedite, they shouldn't be charged, and they wouldn't be charged, and the court reporter and the agency don't make that money. They don't make that extra profit. So for the public members who might not be aware, the court reporting industry, at least the deposition industry, reporters make their living off of selling transcripts, but copies, the original one is billed, original and one is billed at a higher proportional rate than the copies. The copies are not billed at the cost that you would pay at Kinko's plus a handling fee. It's a higher rate, and it's the entire schema for billing that this industry has been built on, and it's a proportional share. The copies are billed at a lower rate than the original in one, but they're not billed at rates that you would pay for a copy of something at Kinko's. It's kind of akin to thinking it's not copyright, but it's, you know, it's a work product. It's how people are making their living. So I have other examples of industries where there's not a commensurate amount of additional work for money to be gleaned for the person who's providing the service, but I'll stop there. Expedited services, as I mentioned before, they're not, it's a super service. It's an extra service to have something ahead of other people. And it's not, to my way of thinking, it's not hurting the consumer to charge them an expedited fee. They're getting a service for it, and they're not obligated to take it. They can turn it down. It's an election that they make, whether they want it right away or not. So I do not believe reporters should be able to, okay, so what's good for the consumer? So you can argue that what's good for the consumer is for it to cost less across the board. But that just makes absolutely no sense, because if you want to just give services free to the consumer, you can't have an industry. It won't support an industry. And so that it's not a simple question. And I hearken back to what our counsel said, that you have to consider the ethics, abuses, the consumer is the highest one that we have to consider, but you also have to consider the health and ability to make a living of the professionals and the profession to have a healthy economic environment. So it doesn't help the consumer to chase people away and make this an unattractive environment to work in if an agency can't charge the things that are the bread and butter of what they make money doing. So that's one aspect. Okay, so what happens if if the board's position is continued? If we say it's not permissible for expedite charges to be put forward for copies? Well, I think that there will be a lot of shenanigans. I think that some agencies, not all, but a lot of agencies, they'll just bill at a higher copy rate and build in what they would have otherwise had as an expedite charge. And I can tell you that this is not a fantasy on my part. As a freelancer, I've had a dispute in the past with an agency who would not pay me as agreed. And I called opposing counsel, the copy attorney, and I got a copy of the invoice. And sure enough, there was no expedite fee on there. There was a copy at $8 a page, $8 a page. So for public members of our board, that's more than twice, probably 3 times the going rate for copies. So that's just one instance where I know where I saw shenanigans. Sure, they didn't charge an expedite fee, but that's abuse. 3 times the going rate. So that happened because they were denied the ability in their mind to charge an expedite. Another problem with that is frequently when those kind of shenanigans go on, it's not shared with the court reporter, and that doesn't help our mostly women out there working. Many are heads of households. Many are the main breadwinner. And so this isn't something to be toyed with in my mind. I can completely support that it's wrong for court reporters to hold transcripts, to say our standard delivery is 10 days and you're not ordering an expedite, so I'm going to hold that transcript. That is wrong. And I don't know if we want to come up with an alternative, maximum number of days that they can take before they deliver it without an expedite charge. But I can say that abuses shouldn't be allowed. And I do think that that's an abuse of the captive, non-noticing copy attorney. I can support transparency of charges. I think it should be clear to the consumer and the attorneys what they're being billed for, what they're paying, what the basic copy rates are, what the expedited charges are. I don't think there should be cost shifting. And as I already said, I think that abusive and unreasonable behavior, once again, we have that word unreasonable, shouldn't be allowed. And then I'll leave with I think one of the strongest points, and that is that we are an unregulated industry as far as prices. We are not regulated. We were at one time regulated, and we're not anymore. So as a board member, even if I weren't torn or conflicted in my mind by all these other points, I just can't support picking out one thing and trying to control or regulate it. And so I'll leave my comments at that. Thank you for indulging me, everybody.
I believe Board Member Manayan and then Board Member Tagare.
Thank you for your passionate words. It's made me take a different perspective. And it's entirely different coming from a working order. So thank you for that. Just for a point of clarification, is the current position and the staff's recommended position that if a party orders an expedited deposition, that so long as they pay the expedited fee, the balance of the parties can also get an expedited copy and they don't have to pay an extra charge? So someone, the reporter or the reporting company is getting an expedited fee. It's just they're collecting it from one party and not the same fee from all the parties.
Because the view is that
It's an electronic
You're-
copy.
you're getting charged to transcribe it. The transcription only happens once.
Correct.
And so that's just one fee.
So, but someone is getting paid extra. Okay. I think if I'm not mistaken, I think one of the positions that you said you can support is not withholding copies of a report from, or of a transcription from the balance of the parties that did in order to expedite. So is that a position still that, do you find unfair? Someone, I want to clarify that someone is getting paid an expedited fee. It's just, if there's 4 parties involved, one person says, I will pay the expedited fee. Should the other 3 parties, I think that's the issue, right? Should the other 3 parties in that 4 also be obligated to pay the expedited fee?
That is exactly the issue. The issue is the other parties, if they say, yes, I want it expedited. Yes, I want it, say the delivery is requested for the next day. Yes, I want it the next day. The standard in my long experience has been that there is a percentage charge for everybody who wants delivery that day. So the actual fee, dollar-wise, would be lower for the copy attorneys because it's based on the lower copy rate, but there is an extra charge for their getting delivery the next day. So when I said I would support not holding the transcript, what I mean is that sometimes what people have done is said our standard delivery is 10 days. If you don't want it expedited, you'll get it in 10 days. And I can't support that because the bulk of the work, the reporter producing the transcript, has happened, and the rest of the work is going through the production and the considerations for work product and income. So I would be in support of, I don't know, saying it must be delivered within 3 to 5 days after an expedite has been delivered to other people or something, and no more than this long.
Yeah, see, that's the issue, right? It's if the other 3 parties do not want to pay the expedite fee, that means do they have to wait the 10 days? That's the issue. Or like you said, is there a shorter amount of time that they have to receive the copies within? I get both sides of the argument, right? The bulk is the production of the transcript. You can't force a fee onto others, the other parties who aren't requesting it, if they don't want to get it expedited. If one person chooses to pay the premium, then that's their choice. The other parties shouldn't be obligated to pay the premium if they choose not to. But then the question goes to, okay, to your point, when are they required to get a copy of that transcript at the same time, or do they have to wait? And that's really the crux of it here, is where one party takes position where the others don't. I can go either way, but I think in light of, the arguments of the reproduction, right, going in digital and not having that extra step, I can see how that makes sense. As an attorney, when I draft memos for clients and they take that and they share it with other parties, I don't believe I'm allowed to charge them. Just, there's no rule, but it's your fiduciary ethical responsibility. So I don't expect to charge the same amount of money that I charged each person reading my memo, the same amount, because I didn't spend 3 times. It's unethical for me to charge 3 times 3 different clients the same amount I would if they're just getting a copy. So from that perspective, I think it's how much work did I do to transcribe that, and I should be commensurately paid for that. The copies, production of copies, I shouldn't be getting paid the same amount from each party for the work that I produce. It's the actual transcription that is the work that needs to be compensated for.
Thank you. I would like to point out before Board Member Tagati makes her comments that the direction we have in regard to this issue is Code of Civil Procedure, Section 2025.510D. And in addition to the fact that fees are not regulated for freelance court reporters, this talks about expediting. Somebody can order an expedite, and it took me about 5 times reading this section to even understand what they were talking about. But the important part is the reporter, if somebody orders, if attorney A orders of an expedite, and the reporter must make the copy available, make that copy of the full or partial deposition transcript available to all parties at the same time. It doesn't, and actually that I believe is what Ms. Pierce pointed out. It doesn't say deliver. So this is the only guidance we have, and it doesn't say anything about cost for the ordering party, attorney A or attorney B, right? And the only other thing I want to point out is years after the board came up with the last position in 2014, the current position the board has, the case of Serrano versus Murley Plastering Company came out. And this does talk about the issue of expedite fees for copies. And it does contemplate a reasonable fee for an expedited copy. And there's lots of discussion around what's reasonable. But just so you know, to me, that's our guide. Those are the directions we've got to work with. And you made the comment about well, I'll leave it at that. I'll let Board Member Tagate speak, but I just wanted to point out those are the two pieces. I have copies of that 2025.510, but again, we can't share them because it hasn't been made available to the public.
I'm sorry, this is legal if I may. What is it that you have? You have copies of?
CCP 2025.510.
We can provide that, and we can provide it after the meeting. That is something publicly available to anyone.
To
who
anyone.
wishes to look it up. Would not be an independently created document.
Okay.
So we can absolutely refer to and provide a copy of that after the meeting. I did want to add, if I may, that same provision of available at the same time to all parties and their attorneys is also mirrored in 2025.350 of the Code of Civil Procedure. And this is what the commenter had referenced into what is made available. Is it made available in providing a copy or the original to parties that have paid, or made available to purchase at an expedited rate, and then a delay if you are unable to pay that. And I also wanted to note that in 2007, the legislature provided some very vague guidance, but what they had and is understood to be one of the bases for the board's current position is that the Legislative Digest provided that their intent was that the obligation to pay for transcription or other depositions, products, or services shall be the responsibility of the requesting party. And that was when they made changes regarding that the requesting party shall bear the costs, which one of these would be the services of expedited. And then there was a separate provision providing that the copy can be received by all parties that request one. So that is some of the legal history provided.
As long as you're offering some legal history, and hesitate to put you on the spot. I really do. And maybe I should have kept my mouth shut, but I started
I'll
it,
do my
so,
best.
Serrano. The case, are you familiar with the case of Serrano?
I have
And
some familiarity with it. I don't know that I can respond with expertise, but I can certainly do my best.
because it's my understanding that Serrano says there must be a reasonable amount for the service of providing. Let me read that. Let me state it correctly. The expedite fee must be a reasonable amount, but it did contemplate an expedite fee for a copy. And again, that would, in my opinion, an expedite fee would be commensurate with the copy charge. You don't charge the same expedite fee for the O&1, which we know is at a higher rate, as you would on the copy. But that case does, my understanding is, when it came back on appeal, or on appeal, I should say, the appellate court contemplated an expedite fee for a copy. Is a reasonable expedite fee on a copy may be charged.
I do have the case and some notes if you give me a moment. I do know that on appeal, the main focus was on attorney's fees, but there was mention of the transcription fees. So if you allow me to refresh my memory, I'll go ahead and get back to you.
Sure. Do you need, should we hold on? Should we stop? Or can we keep hearing other comments?
That is your choice. If you would like to take a break while I take a look, that is fine. Otherwise, you can continue the discussion.
Keep discussing. I'd like to hear what Ms. Tagada has to say.
Okay. Thank you.
Sure, and I just want to thank Ms. Brewer again for her comments. I think that has really shifted my thinking on this issue. You know, coming into this discussion, and you know, looking at the issue now, I almost see this as akin to residuals for writers or actors, in that this is the way that court reporters continue to have this be a sustainable job, which is ultimately, you know, as we've been discussing over the last 2 days, really critical for the workforce, but really critical for access of the public. And when we're talking about consumer protection, you know, we've heard over and over again that the perceived shortage that we have is really a critical issue that we need to address. And so I think that to the degree that we can address, you know, I also concur with Ms. Brewer's thoughts that perhaps withholding, you know, withholding is a problematic solution. And so perhaps the board can pursue some alternative language that strikes a middle ground where we are clarifying and perhaps this requires some legislative intervention or some legislative guidance to further clarify what would be required of the non-requesting parties, if that's the case. But what you know, just to conclude my thoughts, I know that the Legislative Council has been moving towards technology neutral language increasingly. And again, you know, we've been talking about this in the case of machine writers versus voice writers. And I think that this case is no different. You know, the way in which the reproduction is happening, you know, it's still part of the workload. And so there's not, while the methods might change, the process of the work is largely the same. And so perhaps we need to find a different way to regulate that, the business side of that process.
Board Member Minaya?
Thank you for that. Question, who owns the intellectual property of the copyright of the actual transcription?
Reporter. It's the work product of the reporter.
So that's why I'm trying to make that correlation to writers and actors is the intellect, the rights are the reporters, correct? Okay. I think just to take the points of view that were said so far, expressed so far, I don't think I'm generally a person, my view is I try to not overregulate things and let the market dictate. If there's different court reporting boards that are charging higher fees, court reporting agencies or reporters that are charging higher fees than others. And there is other reporters that are charging less fees for copies or expedite fees. The market will adjust, hopefully, at least that's part of it. Because consumers are shopping for the best product and best price. So I think that's one perspective. So I'm not for limiting a person's ability to earn, especially if they've gone to school, trained for that, and that's their craft. So I see that. And I think maybe a kind of a midpoint is maybe a reasonable fee for a copy may be charged for additional copies. I think that's something that I'm open to considering and adopting if that's something the balance of the board and our staff believe that that's something that is reasonable.
Let me clarify, are you saying a reasonable fee?
For a copy.
And then are you saying that you're open to considering a reasonable expedite fee based on that copy?
Correct.
Yeah. Okay.
In light of the case that you mentioned and subject to hearing further clarification from counsel, I think if I'm open to that, but I can be persuaded the other way too if there's
Okay.
reasonable arguments.
I just wanted to address one quick point that you made, Mr. Manayan. It's not a true free marketplace. The noticing attorney gets to choose the court reporter, and all of the copies are stuck with that court reporter. They don't get to choose. They don't get to say, oh no, your copy prices are too high, whatever. So it's not a true free market. Just wanted to point that out.
Geoffrey?
So I do not profess to be an expert on in these cases, but it looks like in Stefan 1, the court ruled that a copy fee could be reasonable and sent the matter back to the trial court to determine whether or not an additional fee onto the copy was considered reasonable. The trial court found that it was unreasonable, and it went back up for Stefan 2 to the appellate court. The appellate court stated that they did not per se believe that an expedited fee for copies was unreasonable, but merely that it had to be reasonable. In 2012, legal provided guidance to this board, and the guidance is that in a situation where the party who noticed the deposition had already paid the expedite fee, a reasonable fee for a copy of the transcript would not include any amount that compensates the deposition reporter for the cost to expedite the transcription. The legal guidance also said that charging the expedite fees to both a noticing and non-noticing party would be unreasonable, and such conduct by a reporter would be unprofessional conduct under the Code of Regulations. It is my advice that the board codify exactly what it means by reasonable. The board is fully within its rights to make a determination as to whether or not for an expedited copy, a certain percentage, for example, would be within the realm of reasonable. So in order to kind of weave that line between what is law and what is not law, but this is one of the reasons that this position It's improper for it to be a policy position, and in fact must be codified in law, whether that be statute or regulation, we can discuss later, in order to not only provide courts and court reporters with solid basis for how they set forth their fees, but that there is clear notice to the consumer. So one of the things that Stefano too said is that if there's notice of a fee, that, for example, if the expedited fee is an additional $500, and for the other parties, it would be an additional $100 or, $150 per page instead of $1 per page, this would at least be notice to the non-requesting party of how to receive in accordance with the Code of Civil Procedure at the same time. It's available, I can pay this expedited rate. However, the statute, or it's not the statute, I'm sorry, the case law does not explain what happens if the non-requesting parties are unwilling or unable to pay this additional rate, and whether or not that renders this unavailable to those parties because they have to wait an unknown period of time until they can receive it at a standard transcription rate.
And may I ask for a clarification? You were talking about Stefano, and then you said the 2012 legal opinion. So there was a break in there, right? That was the information provided to the board that they based their decision on in 2014, that it was not permissible to charge an expedite fee. You were
Correct.
pointing out.
All I have is
Yeah.
that's why I quoted it.
Yeah.
So I'm not 100% as to the legal analysis. What I can offer is, if this board would like, I could also perform an additional legal analysis. Oh, sorry. But the advice at the time was that charging an expedited fee that had already been paid was unreasonable, and charging both parties an expedited fee was unreasonable. It does not appear that the legal advice at the time or the legal question at the time was if a reduced price, but still an expedited price, could be provided for a copy.
Okay. And I'm sorry, I was just clarifying that was in 2012. Stefano was 2018, so years after the board took the position they did in 2014. And so that's new information that has come out since that position in 2014. Yeah, sure. Board
Just-
member Dodge, yeah.
Thank you, Madam Chairman. Just talking through your point to make sure I understand as well, what you're saying is that this legal analysis from 2012 potentially has been updated based, not on a legal analysis, but actually by court precedents or court ruling, appellate court ruling, that, if I understand correctly, said that a expedited fee for copy is not unreasonable. Is that right? So hence that would be a potential change that could lead to, if we did a legal analysis today, it potentially could come up with a different conclusion than what was determined in 2012. Is that what you're?
That's my understanding.
Yeah, the court ruled that an additional fee for a copy was not unreasonable on its face.
Okay, for an expedited.
But when they sent it back to the trial court did find that it was unreasonable. And so this is where the board must speak in law instead of policy and internal discussions or even public discussions. But with the vibe of the board at that particular time, it needs to be something that provides notice to the consumer, to the court reporters, exactly what they're responsible for, especially if they can be held to enforcement action for conducting unprofessional or unreasonable activity. And so this needs, whatever the board decides and how they wish to interpret the law. And of course, courts would then follow the interpretation provided by this board, whereas they had nothing when going into these cases. So that is where the board must speak in law.
I just want to offer, my position would be freelance fees are not regulated for a reason. I don't think it's prudent for us to start trying to regulate fees. Certainly, fees have to be reasonable, and any expedite fee would need to be reasonable, and notice needs to be given in regard to those to an expedite fee, but, and so I'm in agreement with that. I'm in agreement with that. So, Mr. Manayan and then Mr. Dodgenham.
I think I'd agree with that. We need more information, and I'd like to see a legal analysis, a little bit more in-depth legal analysis of see what is reasonable, what isn't, and what we can regulate. Again, I don't think, I don't want to take a preemptive step in regulating something that I don't think we're fully understanding of what the parameters are at this time. Not sure what the rest of the board's position is, but I think we need more information. I'll wait to hear what Board Member Dodge has to say, and then I'd like to make a motion after that, if possible.
Yes, I have three different questions or points of clarification. So first one is, it sounds like our legal general counsel is suggesting that because of the vagueness of the current guidelines, it's very difficult to hold anyone accountable under disciplinary action. So therefore, the recommendation is that we do, either now or at a future date, come up with some detailed direction on this particular point. Is that correct?
I don't know if it's our position to be proposing legislation to regulate fees. The end result of a decision that the board makes, whether it's reasonable to charge an expedite fee or not,
I don't think it's an
is
expression
the,
expedite. fee.
the outcome of that is whether the board would find it grounds for
Discipline.
discipline for a reporter to charge an expedite fee on a copy, a reasonable expedite fee on a copy. That's, am I missing the point? I mean, that the final, we need to make a decision whether it's permissible to charge or not permissible to charge. So the board staff has direction on whether it disciplines someone for charging an expedite fee on a copy. And that is a question. That's a question mark on the end.
Yeah, so we do have to make a decision on whether or not you think it's reasonable. I think I've heard clearly from board counsel that we do need to do something with it, whether it's regulation or statute, we'll get there, just so that then the board could take action if there was a violation. That make sense?
Yes, so to add on to that, that's exactly correct. If the board prefers to go this route today, we can go through some of the pluses and minuses to regulation versus legislation. Of course, if we provide it to the legislature in order to provide guidance or law, they can set forth what we would then further interpret for our particular industry. However, the legislature may not exactly codify proper intent or language, but the more guidance that we could provide them, the better hope that we have that we get the law that we need, or that the legislature properly interprets what their exact intent for this industry would be. But that would be the goal, that whether it's codified in statute or it's codified in either our own practice act or in the government code or in the Code of Civil Procedure, but it's codified someplace in statute or it's codified somewhere in our regulations so that there's full effective notice and that we can fully enforce the laws of our provisions.
So the board takes a position and then we codify that, we make efforts to codify that position. Okay. Now it finally, the dots connected in my brain.
I have two more.
Oh, yes, and I know you said I have 3 points and I jumped in on
Oh,
one.
sorry. No, it's great. No,
yeah.
thank you for jumping in, because I did want to resolve each one. The second one is a little understanding of the urgency. Has this been something pending that we must make a decision today, or because I think there's a possibility of getting more information? So I want to understand what's driving the urgency at today's board meeting.
Well, keep in mind, and we want to make the correct decision, right? But this issue has been, was brought to the board before the last board meeting. And so I guess that would be the reason
Timely
why,
response,
right?
Okay, thank you.
And if I may
Mhm.
assist with that, it appears that at least since 2007, this has been a question for this board and has come before this board several times. So the intent of public safety as well as notice would be to codify something as quickly as possible, but codifying in itself can take a long time. So simply beginning the process is where we need to begin and simply continue to make steps until it's accomplished.
Great, thank you. And then my third and final question is, want to better understand, my concern from a consumer protection standpoint is that what it does having an expedited fee if one party chooses by paying more money, does it give them an unfair advantage by getting the transcript early if the other sides cannot afford to pay that additional fee? Does that create an inequity that we need to be aware of from a consumer protection service, that one side can pay for the privilege and I just don't have a full understanding, getting it 5 or 10 days in advance, does that give them an unfair advantage in the rest of the proceedings that we need to protect those that may not be able to afford it?
And if I may assist with that question as well, that is part of what needs to be interpreted, either whether or not it provides an unfair advantage. The legislature did codify in 2 different codes of civil procedure that the party it shall be available at the same time, specifically for the purpose of due process and lack of unfair advantage and all of the points that you've raised. However, what is meant by the term make available,
Mhm.
and if a party is unable or unwilling to pay, when it becomes then provided,
Mhm.
even if it's available at the higher rate, when does it become provided at the lower rate? So all of that would be part of the interpretation that either this board would set forth in regulation or provide to the legislature.
And before Ms. Brewer answers, I just want to say that we do have the TRF available to not only pro bono firms, but also pro per firms. So that there is access to that. And I had a second point and it's out of my head. Ms. Brewer.
Thank you for recognizing me. So legal services generally are expensive. Court reporters are expensive. But in the scheme of things, 1 hour of attorney time almost always is more than an expedite fee unless you're talking about a long, large deposition. Expert witness time is more expensive. So in the scheme of things, I can't say across the board, it's one of the lower or mid-range costs, but it's certainly not the highest. And I had another point there. Oh, so this also kind of touches on things. You know, reporters are prohibited from doing things like providing transcripts to be paid if the attorney who is on a contingent fee wins. You can't do that because then you have an interest in the litigation, in the outcome of the litigation. So it's a touchy subject because yes, and I do have a concern for a litigant, maybe who's not indigent, but just it's hard to keep up with all these costs. And if you're going up against somebody who's very well heeled, they can run you into the ground. They can and they will. And there are some attorneys who use abusive practices of spending and money to disadvantage their adversary. So it's a very good point, and one that deserves consideration, but you do have to remember the duties of the reporter. The reporter can't be interested in the outcome of the litigation.
Robin, this on?
Yeah, I think, yes, yes.
Thank you. I just wanted, I'm not jumping in on the argument. I just wanted to clarify that the transcript reimbursement fund is not going to help anybody to get anything on an expedited basis.
Oh.
So I don't want to put that out there and imply that that is an avenue that will help in this situation.
You mean get it fast? But it's available for any transcript. There's no limit on
Yes,
what,
but-
but not immediately.
Specifically, we're talking about expedited fees. And there is nothing in the TRF that would be processed in time to make this useful. We would not be
No.
useful, the TRF would not be useful or practicable to be used for expedited fees. You can, you can get them back maybe someday.
Down the road.
Yeah. I just didn't want,
You're just not fast.
the impression was they can always just go get the money here.
And I did not mean to imply that for a second, but from a standpoint of fair, I can't participate in this lawsuit because I can't pay the fees. Yes. I'm sorry, that's why I meant that's an avenue, but absolutely, it's not a quick avenue as we know from our prior discussion. I am told that someone in the audience has raised their hand, so I would like to call on them. And I know both of you both Board Member
Motion to-
Tagade and Manayan want to make comments. So Ms. Leslie, I understand you have your hand raised. And you have a comment?
This is the WebEx moderator. To be clear, are we opening for public comment at this time?
Yes, thank you.
You're very welcome. I'm going to display the instructions. If someone would like to make a comment, they may click the hand icon to raise their hand, or they can click the question mark icon, which will show in just a moment, and type the word comment into the text box there and click send. So we do have two people with raised hands. First is Stephanie Leslie. And Stephanie, I'll send you a request to unmute your microphone and you will have 3 minutes with a 30-second warning. And you're unmuted. You can begin.
Okay. So a couple of points. First of all, I wanted to thank Ms. Brewer for her very eloquent comments and for speaking on behalf of so many of us. First of all, I wanted to introduce myself, Stephanie Leslie. I'm the president of the DRA, the California Deposition Reporters Association, but I will be speaking on behalf of myself personally. I'm also a firm owner, so I have a perspective in that way, as well as a working reporter. I appreciated Ms. Brewer's comments that we are an unregulated industry. And so we do have to tread lightly with that. So I appreciate her bringing that to our attention. The other thing I wanted to make light of that I don't know has been addressed yet, but if the opposition at the heart of this is that we are somehow double dipping for our fees, I would retort with that we charge both sides fees for every other kind of service. For example, our rough drafts, for our real time. So I don't think that should be a consideration. And we are actually obligated to be neutral and to charge equally to both sides, or else we could be seen as favoring one side or the other. So this is an important point, I think. Also, as a firm owner, I do appreciate Ms. Brewer's suggestion to have clarity about when we are expected to release transcripts, if there is an expectation, because I am often sent invoices from reporters charging for expedited rates, and I know the board's informal position recently, and so I'm kind of stuck between a rock and a hard place, and now that I'm my own reporter in charge, I don't want to be disciplined for that or potentially disciplined, so I appreciate you considering that. Also, my last point is the urgency. Someone had mentioned what is the urgency of this, and I guess that leads back to my point before that it is an ambiguous position, and if we have more clarity, we would really appreciate it, although we don't want to be regulated at the same time. So I realize the sticky situation. So thank you for taking my comment and for considering this quickly. Thanks.
Thank you.
And our next request for comment comes from someone logged into WebEx as Kelly Zolars. Kelly, I'm going to send your request to unmute, and you will have 3 minutes with a 30-second warning. So you're unmuted. Go ahead. Hello.
Hi, I'm a freelance court reporter for 40 years in the San Francisco Bay Area. I am a very nervous public speaker. I jotted down a bunch of notes, but I had to raise my hand just to comment on a few of the things we're discussing. And some of them are just reiterating the same things that Laura and Stephanie just said. The copy expedite charge is just a percentage of the page rate. It is not the same as what is charged for the O&1. We would also be favoring the copy side and not being impartial officers of the court if we charge one side and not the other to provide equal services. We do the same thing for real time. We do the same thing for rough drafts and other services we provide. And I also agree with Stephanie that, oops, where did that go? Sorry, I have scribbled notes and they're really bad. And for those saying that indigent or people who can't afford to pay for expedited services, the reporter who earns $50,000 to $75,000 a year should not be the one who has to be penalized for that. There should be other avenues for them to be able to pay for that. And my suggestion would be sometimes it's not always the next day expedite. It will be a 3 or 4 or even 5-day expedite. So if the board is going to make a recommendation that way, I would suggest 3 to 5 days after the expedite is provided as a reasonable time to provide that copy they're not getting paid for. Sorry, not very eloquent today. The other point was Serrano was a ruling about a court reporter working in court. So that person also gets salary and benefits, something a freelance reporter does not receive. So they are being compensated in other ways than freelance deposition reporters are. That's enough. Thanks for hearing me.
Thank you.
Okay, we do have a question from another user. Let's see, Kelly Shaneline. Kelly, I'm going to send you a request to unmute your microphone so that you can have your 3 minutes. Hopefully you'll see that pop up. And Kelly, you should have gotten a pop-up on your smartphone with the option to unmute me. All right, we will come back to you in a moment. We have a comment from someone logged into WebEx as Kathy. Let's see. All right. Kathy is no longer logged in, but she did, oh, okay. I see. She does not have a microphone or camera. Shall I read that comment aloud?
Please.
Kathy's comment is, you mentioned a reporter cannot wait for payment on a transcript based on the outcome of the case because that would put us in a position of being partial. What about the court reporting agency that allows attorneys to pay after their case resolves? Does the board need to address that court reporting agency for favoring those attorneys and the outcome of their case?
And I would,
If I could, I will defer to you, but if this is not on the agenda, the board cannot comment or discuss that.
yes, I agree.
All right. So we do have a raised hand from, let's see. Oh, now Kelly Zolars. It looks like you are unmuted. Did you have a comment?
Actually, I think we've already heard from that
Okay.
speaker.
Thank you
And
so
I
much.
want to remind everyone that if you're agreeing with someone who has commented previously, please state that so we can move on. We appreciate all your input. We just, that would help us expedite things.
And our next request for comment is from Anna Costa. Anna, I'm sending you a request to unmute your microphone. You'll have 3 minutes with a 30-second warning, and you're unmuted. Oops, now you're muted again.
Okay, can you hear
There
me
you go.
now?
Yes,
Thank you.
you're welcome.
I only caught a portion of Ms. Brewer's comments. I had a meeting out of the area. But I do want to agree with the majority, well, everything that I've heard Ms. Brewer say today and also my speakers before me. One comment that was made, I believe it was Mr. Nyan, about market charges. And I'm not sure if you know this, that the market changes almost from city to city. Their agencies are not able to charge, for example, for per diems or an hourly charge for a court reporter to be present in many areas. And then there are other areas where they are. And the page rate can vary significantly and definitely in Southern California versus Northern California versus New York, et cetera. And that, you know, the majority, I've been in this field for 44 years, and the majority of court reporters that I know are ethical, and they are not in it just to make money. It's out of a deep love and devotion to being a neutral guardian of the record. And they do their very best to follow all the laws by which they are regulated. And so there are agencies, of course. I believe Ms. Brewer or somebody was referring to shenanigans. That definitely happens, even outright fraud by some agencies, especially the big box agencies. So keep that in mind. If you're going to set some kind of rate structure, depending on length of time, I agree that it's not really, it doesn't feel right to hold back a transcript that's already ready because somebody doesn't pay the expedited fee. It doesn't feel right. But also many reporters are independent
30 seconds.
contractors. So they are dependent on this for their income. Many are, of course, the majority are female, and they have a lot of, you know, they have their families to support. So please keep all of that in mind, whatever you decide to do. Thank you.
Thank you.
And our next request for comment, let's see, is from Kimberly Elizabeth Durso. Kimberly, I'm going to send you a request to unmute, and you'll have 3 minutes with a 30-second warning. You're unmuted. So go ahead, Kimberly. Okay, Kimberly, we're not hearing your voice. All right, Kimberly, you muted again. I'm sending you another request to unmute. It may be that your computer isn't recognizing your headset. Next to the mute button, there's a small little arrow. You might want to pull that down to choose your headset or your computer microphone. You're unmuted again. Let's try this again. And Kimberly, I'm not hearing your voice. As with the others, if you have access to that question mark Q&A icon, you may type your comment in there. And okay, Kimberly says it's not unmuting. You appear to be unmuted on our side. So at this point, the only thing I can suggest is typing the comment into the Q&A. And I will check back one more time with Kelly Shaneline. Kelly Shaneline again, I'm going to send you a request to unmute and see if you can get that notice up on your smartphone, and then you'll have 3 minutes. So Kelly Shaneline, I would also encourage you to look for the question mark icon on your WebEx device. It may be behind the 3 dot other options if you're on a smartphone, and type your question in that question mark comment area. Oh, Kimberly Durso, are you able to? There you go. I hear you.
Are you able to hear me now?
Yes.
Oh, wonderful.
Great.
Thank you. I don't know what was happening there, but I'm glad I'm connected. My name is Kimberly Durso, and I am president of an organization called Protect Your Record Project. And I want to thank from the bottom of my heart Laura Brewer for bringing her institutional knowledge and an intelligent perspective to the issue. We support what we said, and we also appreciate that the members take their time on this issue, as was suggested. And I also affirm the comments that Anna Costa just made, as well as Stephanie Leslie from DRA. Thank you very much.
Thank you.
All right. And let's go ahead and I have not yet seen a message come back in from Kelly Shaneline. So we might need to move on without that. Do you recommend that anyone who needs to can email or phone the board? But at this time, shall I close the public comment feature?
Yes, please.
Thank you.
So I believe Board Member Tagade, then Board Member Brewer, and then Board Member, that's the order, well, Manayan, sorry, to finish that. And then,
I have a couple questions for clarification and then just another comment. I know Ms. Fenner spoke to the TRF being perhaps not the correct way to address an inequity with expediting, with expediting. Is that, just to clarify, is that not permissible under the current TRF language, or is that, or is it just because of the timing of the TRF?
The point was the timing.
Okay.
It takes several weeks for applications to be processed. So by the time it goes through the process, it's not going to be, the expedite time will have passed.
No, that is helpful, because I wonder if there might be other avenues to explore there.
can I just answer that too by saying, even if it were a regular 10-day, just for clarification, even if it were a regular, I think 10 business days perhaps as regular delivery, the TRF wouldn't come into play in that 10-day window either. So it's, the TRF is designed.
It's a reimbursement fund.
Thank you. Yes. So does that,
Yes, that is helpful clarification. And the other thing I just wanted to note. I think regardless of where we land on this issue, and I think I certainly think that the current status quo cannot stand. I think at a minimum, the board should take some action to at least require some clear notice of fees, one way or the other, for all parties. And so at a minimum, I think we should absolutely move for at least that regulation, or that policy rather.
Ms. Brewer?
Thank you. I just want to say one point. I'm not here on behalf of the industry. I'm here on behalf of the consumer. But my points of view are informed by my 40-plus years as a CSR and working in the field and understanding the economics of it and the machinations of how the industry works.
Thank you. Mr. Board Member Manayan.
Thank you. I'd like to make a motion. On item number 10, I'd like to make a motion to request legal to provide additional legal analysis on what is reasonable and on this issue in particular. Sorry, I know it's a task. I'm putting more work on you, but motion for additional feedback, options for the board, including whether taking action via the regulatory or the legislative path is the pros and cons of each. I think we need more information to make a decision here.
I'm happy to do my best, and a motion is fine, but also a motion is not necessary if I'm so directed.
Okay. So and my motion is just to, that's like how we should further this for future discussion.
And Board Member Dodgenham.
As I understand it, there's a request that we as a board take a position, and there still is a question of whether that position will then be implemented through statute or regulation or some other path. And so I'd like to discuss taking a position today and make a proposal on an opinion on taking a position. And so,
Point of clarification, I do apologize.
thank you.
There was a motion on the table. Was it withdrawn?
It was not.
Okay, then it needs a second, or it dies, and then another motion can be made.
I'm sorry, I thought
thought you said it didn't
I
need a
thought you
motion.
made a motion, you said it wasn't necessary to have a motion, and you
Right.
withdrew it.
No, I kept my motion
Oh,
to
you,
get request further information on this matter and not take a decision, not take a position today.
okay,
And the motion is perfectly fine as a
Yeah,
formalized
oh.
instruction.
okay, I was, well,
That
okay,
was confusing. So I understand. I withdraw my motion, but, and I'll talk during comments about this motion if it continues on.
do we have a second for the motion? So, yeah, so the motion's off the table? Maybe that's not the that's probably not the appropriate way to say it. Board Member Dodgenham.
Thank you. I would like to propose that this board take the following position. We can figure out how we frame it, that we will allow and put on our website that expedited fees for copies are allowed, but with the condition that if one party receives an expedited copy, the other parties must receive a copy within 3 to 5 days of that period. And I don't know if I talk about why now or talk about that later.
If I could make a point of
Mhm.
clarification, that would be an interpretation of the law, and it would be
Not
my
regulation.
advice to this board that that be done rather than a posting on the webpage, than instead a codified interpretation of the law. And as stated before, there are provisions within the Code of Civil Procedure that the parties be made available, and the board would then have to further define why a delayed transcript is still a made available, and we're continuing to interpret law, which under the Administrative Procedure Act is required to be done in regulation or superseded, obviously, by legislation. So I am uncomfortable with advising the board to proceed with that action.
And if I understand, then you're saying the way to do that would be to put it in regulation, or that requires legislative action?
An interpretation of law by this board would be done in regulation. So that this board cannot interpret law
Yes.
without a regulation. However, of course, the legislature has superior rulemaking ability above our own. And so if the legislature, either we sought legislative change or the legislature on its own made those changes, then that would supersede our duties under regulatory action.
May I ask for a clarification from you, Ms. Joffrey? And that is, would an appropriate, and I'm not suggesting this is what you want, but would an appropriate way to make a motion be to that the board take a position one way or the other on whether it's permissible to charge a reasonable expedite fee, and that the board follow up? Can it be tied in any way to, or is it automatic that the board would follow up with some type of legal regulatory change? Or are the two, or do they have to be both mentioned in the motion? Like, if the board takes a position and
If the board feels that it has enough information to take a position, the board may make a motion to take a position and then vote on that motion. And then the board can separately determine whether it would like to pursue legislatory action or regulatory action to do so. And then staff can prepare guidance to that effect to present at the next board meeting.
And as a point of clarification, does that position can only be whether we believe expedited fees for copies is reasonable or unreasonable? Or can it have, as I described it, a condition to it, such as the time period it would take for other parties to get that?
What the board can do is probably break that down, so it's not a compound decision, so that the board can make decisions step by step. First, whether or not it would be reasonable. Second, how to go about it. But that position would not become the formal position of the board until it was codified, if that assists you. But yeah, at that point, staff and legal would then be advised to pursue that particular direction, as opposed to the more general position of this is more information for the board to make a decision.
It is, I'm sorry. I'm going to, for the moment, withdraw my motion and see if anyone else has a better solution.
I'm going to make it very clear. I want more information from legal to see what the legal parameters allow us to do before we take a position one way or another on regulating whether we can regulate the charging of expedited fees for copies or not. I don't have enough position today to take a position. So whatever motion we need to make, I would request legal to advise on the wording of a motion that would allow us to not make a formal decision today, request for additional information from legal counsel on what the law is and the different options of pros and cons of how we can move forward with this. I don't know what that motion is, but that's the motion I'm requesting. So I'd like to defer to Chair Sankis to help us close this matter out so we can move on to the next agenda item.
And perhaps we just direct staff and legal staff in particular to provide the information at the next meeting, to do some research and provide the more information at the next meeting so we can revisit this issue. Board Member Brewer.
I support the direction to get more information. My question is, can we do anything in the interim about direction? I would hate to see somebody disciplined on this issue while it's pending.
So whenever there's any kind of a question, then we just hold it in abeyance.
Perfect. Thank you.
And Board Member Tagade.
In addition to Mr. Manayan's request, I think And I apologize for continuing to add work to the wonderful, wonderful Court Reporters Board staff. But I think what might be useful in terms of additional information for us to be able to make an informed decision might be a little more on the impact. And so if perhaps the scale of the issue, like how, the extent to which this is an issue, like to the extent that we know, if it's possible, the number of cases that are coming up if possible. And maybe we don't have answers for that, but I think that would be helpful. I know we're hearing kind of from Ms. Brewer and from our public comment that this is relatively standard practice, but you know, I know some of our materials say otherwise, and so I think it would be helpful to have a little better sense of that.
Are you wanting to know how many complaints we receive, the board receives in regard to this practice?
Yes, and
Is
I
that what,
think
is that what you're?
and in particular to differentiate how often it's happening that a firm is charging for the expedited copy, like entirely anew versus excuse me, the expedited transcript versus the expedited copy, I guess, the reduced fee.
Oh.
And I imagine that this will be difficult to track down. And so it's, if this is not feasible, then it's totally understood. But I think that those are the kind of the information points that I'm kind of struggling with.
Okay, I think everybody's clear on what it is that we're asking? Okay,
Legal understands the assignment, yes.
thank you very much, Ms. Joffrey.
Mhm.
Appreciate it. Okay. So, let me move. That brings us to agenda item 11. Moving, Ms. Finner, do you have an update as to the status of OPES's work on the evaluation of the CVR?
Yes, Madam Chair, at our meeting in March, the board instructed staff to enter into an interagency agreement with OPES to evaluate the Certified Verbatim Reporter or CVR certification from NVRA or the National Verbatim Reporters Association. Staff has done so, and OPES is currently working with NVRA on the project. I will update you on further developments at future meetings.
Thank you. Do we have any public comment before we move to board discussion?
This is the moderator, and we have opened up the WebEx features for public comment. If you would like to make a comment, you can either click on the hand icon to raise your hand. You can click on the question mark icon and type the word comment in that text box and click send. And if you are a call-in user, you may press *3 to raise your hand. We do have a request to speak from Carolyn Dasher. Carolyn, I'm going to send you a request to unmute your microphone. You'll have 3 minutes with a 30-second warning. You're unmuted. Go ahead.
Hello, thank you for such a very long meeting. You guys are doing a great job, and I really commend all of you for your patience and all your time you're putting into our profession. Thank you so much. So I did want to ask, I think that's wonderful. We're moving forward with NVRA, and can we agendize in the future looking into the same reciprocity with NCRA and perhaps agendize that for next time? Thank you.
We've already done it.
Yeah.
And I do not see any further requests for comment at this time. Shall I close that public comment feature?
Yes, please.
Thank you.
Are there any comments from board members on this agenda item? Okay, thank you. And we will move to agenda item number 12, election of officers. Agenda item 12 is our annual election of officers at the first meeting of each fiscal year. We are required to elect a chair and vice chair for the coming year. Are there any nominations for the position of board chair? Board Member Brewer.
I nominate Denise Tagade.
Is there a second?
I'll second.
The motion has been made by Board Member Brewer and seconded by Board Member Manayan that Ms. Tagade be the new chair. Do you accept? I should have asked you that before I repeated the motion.
I do accept. Thank you.
Do we have public comment?
This is the moderator, and we are opening up the WebEx public comment features. If you'd like to make a comment on the proposed election of officers, you may look for the question mark icon, type your comment there, type the word comment, and then click send, or you may click on the hand icon. We do have a leftover comment from an earlier topic. Shall I give that person an opportunity to speak?
No, let's take new comments, please.
Thank you. Is there any request for comment on the election of officers? And I do not see any requests for comment. Shall I close the public comment feature?
Yes, please.
Thank you.
Are there any comments from board members as to the motion? Thank you. So the motion, I don't need to restate the motion, I don't think. Ms. Bruning, would you please call the roll?
Thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenam.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Tagade.
Aye.
Thank you, Ms. Sunkis.
Aye.
Thank you. Motion carries.
Wonderful. Thank you and congratulations.
Congratulations.
Yes. Moving on to the position of vice chair. Are there any nominations?
I'd like to thank Chair Sunkis for her service as chair. Thank you. And I'd like to, in return, nominate you to be vice chair.
Thank you. And I accept. Are there any other nominations for vice chair?
Second.
And there's a second. Okay. Thank you. So we have a motion by Board Member Manayan and a second by Board Member Brewer that Board Member Sunkis chairs that I am vice chair. Do we have any public comment on this motion?
This is the moderator, and we've opened up the WebEx features for public comment. If anyone would like to make a comment on the vice chair position election, you may either click on the hand icon to raise your hand, or you may click on the question mark icon, type the word comment in that text box, and click send. Are there any comments on the vice chair position? I do not see any requests for comment. Shall I close the public comment feature?
Yes, please.
Thank you.
Ms. Bruning, would you call the roll, please?
Yes, thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenam.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Tagade.
Aye.
Thank you, Ms. Sunkis.
Aye.
Motion carries.
Thank you. So we'll move on to agenda item 13, future meeting dates. Per our usual custom, staff will poll board members offline about their availability for dates. Are there any public comments on this topic?
And this is the moderator. We're opening up the WebEx features for public comment. If anyone has a comment on the future board meeting dates, you may look for the hand icon, click that to raise your hand, or the question mark icon, click that, type the word comment, and click send. Are there any comments on the future meeting dates? And I do not see any requests for comment. Shall I close that feature?
Yes, please.
Thank you.
Do any board members wish to comment on this agenda item? Moving on to agenda item 14. Excuse me, there are no disciplinary matters to consider in this closed session, but at this time, the board will now move into closed session pursuant to Government Code Section 11126 Subdivision 3 to receive advice from legal counsel on litigation as listed on the agenda. Yes, we will report back.